Welcome. This is Democracy Undecided, and today we will explore the history of legal systems, a story without which it's impossible to understand how politics, states, and democracy have developed. According to the United Nations, there are 5 major legal traditions in the world today. The most widespread is civil law, followed in more than 150 countries, including France, Germany, Japan, and Brazil. Its foundation lies in codified statutes, acts, that organize society's rule and are revised only gradually over time. Another major tradition is common or precedent-based law, which operates in roughly 80 countries, such as the United Kingdom, the United States, Canada, and Australia. Here, court rulings play a central role. Each new decision sets a precedent that becomes part of the legal system. While civil codes are updated infrequently, precedent law evolves daily, making it flexible but also more complex to navigate. In practice, though, most countries don't fit neatly into the pure categories. Their legal systems are mixed, blending codes and precedents with elements of religious or customary law. Beyond these two global families, about 30 countries rely primarily on religious law. For example, Sharia in parts of the Middle East. Many African and Pacific nations maintain customary law based on traditions and community practices. And finally, a large number of states operate hybrid systems, where French or German codes coexist with English precedents, religious rules, and local customs. Despite their diversity, all these systems share a common moral foundation. Many of their core principles: do not kill, do not steal, do not bear false witness, honor your parents, trace back to religious traditions, the biblical commandments, the Qurans, Jewish halakha, or the Hindu religious norms. Over time, these values were absorbed into secular law, becoming universal benchmarks for human societies. The first codification emerged in Sumer and Babylon, rooted in customary norms. More than 4,000 years ago, around 2100 BCE, the Sumerian king Ur-Nammu issued a code that set penalties for murder, theft, and treason, as well as rules on the debts and property. This marked the birth of the new idea that the law stands above individuals. His code was not a legal system in the modern sense of the word. It grew out of community customs, passed down orally, and religious beliefs about justice sanctioned by the gods. Law was viewed as the divine gift, and the king merely recorded and organized the god's will. In this sense, the Code of Ur-Nammu was an early example of mixed law, part customary, part sacred. This tradition later inspired rulers across Mesopotamia, including the famous Code of Hammurabi, about 3 centuries later. In 18th century BCE, King Hammurabi of Babylon had 282 laws inscribed on the stone stele. They range from criminal punishments and family rules to contracts and property disputes. His principles of an eye for an eye or tooth for a tooth symbolized proportional justice. The stele shows Hammurabi receiving authority from Shamash, the son of God and guardian of justice, emphasizing that the law was more than royal command, it was divine order. Importantly, Hammurabi's code did not appear out of nowhere. It drew on earlier Sumerian or Sumerian and Akkadian laws, local customs, and religious ethics. Did these ideas reach Greece? There is no direct evidence of borrowing, and Athenian laws were not simply a continuation of Mesopotamian tablets, but the concept of written law that rules could be fixed permanent and applied equally, spread across the eastern Mediterranean through trade and diplomacy. Just as the Greeks adopted the alphabet from the Phoenicians, they may also have inherited the notion that law should be written down. In that sense, Draco in Athens played a role similar to Hammurabi in Babylon. He turned custom into codified law, open to all citizens. This was a turning point. From then on, rules were not just oral traditions or rulers' commands, they were texts with universal authority. If Mesopotamian law was bound to divine sanctions, Greek law added a political dimension. The community itself could decide its laws. In 621 BCE, the Athenian archon, Draco, first systematized and recorded the city's customary rules. His laws were famously harsh, giving us the word draconian, but they made justice more transparent since every citizen could know the rules. In 594 BCE, Solon reformed the system. He abolished debt, slavery, reorganized the courts, and gave ordinary Athenians a greater role in legal proceedings. Over the time, jury courts of hundreds of citizens reinforced the principle that the law was not only an instrument of power, but also a tool of civic participation. Athens laid the groundwork, but Rome expanded the idea into the universal system of governance. In the 5th century BCE, the Romans enacted the 12 Tables, around 451 to 450 BCE, the first systematic legal code accessible to citizens. Rome did not invent this from scratch. Its close contact with Greek colonies in the southern Italy influenced the principle that laws must be written and public. While there was no direct line back to Mesopotamia, the concept of written law had originated in Sumer, developed with Hammurabi, been reshaped in Athens, and reached full maturity in Rome, where it was combined with the jurisprudence, the science of law. Roman jurists went on to define enduring concepts, contracts, torts, and good faith. In 533 of Common Era, Emperor Justinian compiled the Corpus Juris Civilis, which became the foundation for civil codes across Europe, and later through legal reception in Latin America and Asia. The fall of Rome created a new patchwork of laws. In the 5th century CE, as central authority collapsed under barbarian invasions, Rome's administrative system disintegrated. New kingdoms emerged: Ostrogoths, Visigoths, Franks, Anglo-Saxons, each with its own customary codes. The Salic law of the Franks, the breviary of Alaric among the Visigoths, and Anglo-Saxons' dooms. Roman tradition survived in cities, monasteries, and especially in the church, but the balance shifted toward mixed local systems. The Catholic Church became the stabilizing force. It preserved literacy, Latin, and Roman legal thoughts. For barbarian rulers, alliance with the Church provided legitimacy. Papal blessing and baptism strengthened their authority. At the same time, the Church adapted to local customs and became a mediator between Roman traditions and Germanic practices. Thus, a symbiosis emerged. Customary tribal law coexisted with canon law, as church courts gained authority over marriage, inheritance, and morality. Roman law didn't vanish, it was transformed. Meanwhile, beyond Europe, from the 7th century onward, Islamic Sharia law developed, emphasizing bans on murder and theft, honesty in trade, and respect for family. Similar values echoed in Jewish halakha. In Africa and Asia, customary law continued to regulate land, kinship, and conflict resolution. Later, the English stepped toward the rule of law. By the 12th century, royal courts in England were recording precedents creating the basis of precedent law. In 1215, after political crisis and baronial revolt, King John Lackland was forced to sign the Magna Carta. No taxation without consent of the nobles, the right to a fair trial, and the principle that the law is above the monarch. The charter didn't instantly democratize England, but it set in the motion the doctrine of the rule of law. Over centuries, its principles were reaffirmed and broadened as courts built a body of precedent. By the 19th century, English precedent law had become a powerful system in which each judgment could itself become law. This tradition spread through the 17th, 19th centuries to England's colonies, and eventually to the United States, Canada, and Australia. It's important to note, though, that even in these countries, codes, criminal, civil, tax, still exist, evolving more slowly and providing the framework onto which the new precedents are layered every day. Codification and modernization happened in 1804. Napoleon's civil code became a model of clarity, secularism, and universality. It inspired Italy, Spain, Belgium, and later much of Latin America. In the 19th century, Japan adopted German and partially French codes as part of its modernization drive. In the 20th century, Turkey, under Ataturk, replaced Sharia with the Swiss civil code. Each reform was political, revolutionary in France, modernization and Western recognition in Japan, secular renewal in Turkey. The 20th and 21st centuries brought international law and hybrid systems to the new level. After World War II, humanity created a global legal framework. In 1984, the UN adopted the Universal Declaration of Human Rights, enshrining values such as the right to life, the ban on torture, and the right to a fair trial. Since then, UN member states have been expected to align their domestic laws, at least in part, with these international standards. Yet, despite common principle, most countries today operate hybrid systems that combine international obligations with domestic traditions. In Nigeria, precedent law coexists with Sharia and customary law. In India, precedent law is applied alongside religious laws in family matters. In Israel, modern legislation functions alongside religious courts. In Kenya, parliamentary statutes coexist with tribal customs. Law remains a living organism, adapting to culture and society's needs. What we see today is a mosaic. States differ in their formal legal families, but all must respect international standards, while also relying on their own blended traditions. This duality, global norms and local practices, shapes modern law. From Sumerian codes to modern constitutions and international conventions, the journey has been long. Yet the moral core endures: prohibition of killing, theft, and deceit, the demand for justice. These are implemented in different ways, through civil law codes, through judicial precedents, through religious texts, or through community customs. Democracy, law, and economy have always developed together. Democracy without law collapses into chaos. Law without democracy hardens into dictatorship. Only their interaction creates a space where people are both free and protected. If you would like to learn more, follow the links under this video to resources from the United Nations, to the US Library of Congress, the Encyclopaedia Britannica, and historical documents. They'll help you to see how legal systems formed and why they remain so different today. You can also watch this episode in Ukrainian or Russian on our channel. Read to stay educated. In the next episode, we will explore Switzerland, its unique democracy, economy, and approach to security. Thank you for joining us. This is Democracy Undecided.